What is going... Oh, is that audio working? Hold on. I hope the audio is working. What is going on, nerds? It has been a while, and there's been a lot of action in the Supreme Court. So today, we're going to go in there and look at the decision on affirmative action, and maybe a little different than what you're used to seeing in the regular kind of 30-second news summaries. We're going to actually go into the Supreme Court opinion and dissent, time permitting, and just read it together. So if you find this type of content interesting and useful, where we actually go into the original source material versus kind of going straight into opinion, do me a solid. Oh, shit. I think I just lost audio. Hold on. Oh. Hold on. Let's see if audio is working now. Audio, are you working? Let me know if in the chat if you guys can hear me okay. Because I'm having some technical issues, but I think it's working now. Yeah. So setting aside the weird technical issues, if you find this analysis useful, you know what to do. Like, share, and subscribe. And I read and reply to pretty much all the comments. Okay. We have a little less than an hour to do this because I've got another commitment. But let's dive right in. And we're going to go right into the source material, the actual Supreme Court opinion published from the Supreme Court website. So it does not get any nerdier than this. And I'll warn you, it's 237 pages. So we're not going to be able to get into all of it. But we will read for sure the main opinion by Chief Justice Roberts. And then, time permitting, or maybe in a follow-up live stream, I can do the dissent from Sotomayor. Okay, let's get right into it. And I also should let everybody know I am not... yeah, Kevin's like, there's no way you're going to be able to do this in an hour. I know, Kevin. Thank you for being a member, by the way. We're going to give it our shot, our best shot. I am not a lawyer. I do not play one on TV, but I do find this kind of thing interesting. And so let's get into it. So Chief Justice Roberts delivered the opinion. In these cases, we consider whether admission systems used by Harvard and UNC, two of the oldest institutions of higher learning, are lawful under the Equal Protection Clause of the 14th Amendment. Founded in 1636, Harvard College has some of the most selective application processes in the country. Okay, let's make it a little bigger. Over 60,000 people applied to the school last year. Jeez. And fewer than 2,000 were admitted. Gaining admission to Harvard is thus no easy feat. It can depend on having excellent grades, glowing recommendation letters, overcoming significant adversity. It can also depend on your race. The admissions process at Harvard works as follows. Every application is initially screened by a first reader who assigns scores in 6 categories: academic, extracurricular, athletics, school support, personal, and overall. A rating of 1 is best, 6 is worst. In the academic category, 1 signifies near perfect standardized test scores and grades. In the extracurricular, truly unusual achievement. In the personal, it denotes outstanding attributes like maturity, integrity, leadership, kindness, and courage. A score of 1 on the overall rating, a composite of the 5 other ratings, signifies an exceptional candidate with greater than 90% chance of admission. Okay, so the first thing that I will call out here is from just first paragraph. It does appear that the scoring across these 6 categories rates academic uh, achievement as really a minority percentage of the impact. If these categories are scored evenly, I mean, you would have thought that, wow, going to one of these super selective places, it's mostly going to be on your academic readiness. Like, how are you doing in school, learning knowledge, and performing well in the classroom. And if you read this right, it's like, well, that is important. And it's about maybe 16% of the overall decision. The other is extracurricular, athletic, school support, personal, and overall. So that's the first thing that jumped out to me reading this. It's like, wow, your grades, your report card, your test scores, that's 16% of the decision to go to an institution of higher learning, which is to say that 84% of the decision is based on other things that are harder to quantify, like extracurricular, maybe even athletic. Like the fact that athletic ability is the same weight as academic ability, based on this reading, I don't know. Maybe they weight them differently. Like if you told me academic is 50% and then the other stuff is the other 50%, I would have thought that would be more, that's what I would have expected. But, this is what at least Chief Justice Roberts is claiming. What else do they say? In assigning the overall rating, the first readers can and do take an applicant's race into account. Once the first read process is complete, Harvard convenes admissions subcommittees. Each subcommittee meets for 3 to 5 days and evaluates all applicants from a geographic area. The subcommittees are responsible for making recommendations to the full admissions committee. The subcommittee can and do take an applicant's race into account when making their recommendations. The next step of the Harvard process is the full committee. The committee has 40 members, and its decision centers around the applicants who have been recommended by the subcommittees. At the beginning of the meeting, the committee discusses the relative breakdown of applicants by race. The goal is to make sure that Harvard does not have a dramatic drop-off in minority admissions from the prior class. Each applicant considered by the full committee is discussed one by one, and every member of the committee must vote. Only when an applicant secures a majority of the full committee's votes is he or she tentatively accepted. At the end of the full committee, the racial composition of the pool of tentatively admitted students is disclosed. The final stage of Harvard's process, so far, this seems pretty reasonable. There is an assessment by the subcommittee, rolls up into the geographic committee, then goes to the broader committee. They go across these criteria, the 6 criteria. You and I can disagree on how much those criteria should be weighted. I do find it a little strange that athletics seem to be comparable to academics. I always thought of athletics as like a sweetener, but apparently athletics are pretty important. But then you kind of end up with your tentative class. Now, according to, and I'm only speaking to this document, I don't have any knowledge of how Harvard actually does admissions. But aside from being an applicant like a million years ago. The final stage of Harvard's process is called the LOP, during which the list of tentatively admitted students is winnowed further to arrive at the final class. Any applicants that Harvard considers cutting at this stage are placed on a LOP list, which contains 4 pieces of information: legacy status, recruited athlete status, financial aid eligibility, and race. That's interesting. Okay, any applicants that Harvard considers cutting are placed on a LOP list. And to determine who gets lopped of the tentatively accepted, you need to know their legacy status, whether they are a recruited athlete, their financial aid eligibility, and race. Okay, right off the bat, that is kind of interesting. So what they're saying here, according to the opinion, is that once the tentatively accepted students are identified, they now will pull people off and put them on a LOP list. And they will look at criteria like whether or not the parents went to Harvard or family members, whether or not they're a recruited athlete. And, you know, I love athletics. I think you can learn a lot from playing on a team sport and grit. But the fact that it's such a prominent thing here is crazy. And then financial age eligibility seems kind of sad that that's even considered. I suppose maybe they would give preference to people who need financial aid. I hope it's that way, not the other way around. And then race. So that's how what they consider for LOP list. The full committee decides as a group which students to LOP. In doing so, the committee can and does take race into account. Once the LOP process is complete, the admitted class is set. In the process, race is a determinative tip for a significant percentage of all admitted African American and Hispanic applicants. Founded shortly after the Constitution, UNC prides itself as the nation's first public university. Okay, so now we're going to talk about the UNC process. Like Harvard, UNC is highly selective. A typical year receives 43,000 applications for a freshman class of 4,200. Man, UNC. Every application the university receives is reviewed by one of 40 admissions readers, each of whom reviews 5 applicants per hour. Oh, that's interesting. So for all of you parents out there, or maybe some students watching this, all that work you put into that application gets 12 minutes. 12 minutes. Crazy. Yeah, 5 applicants per hour. So I want to make sure my math is correct. Readers are required to consider race and ethnicity as one factor in their review. Other factors include academic performance, standardized tests, extracurricular, essay quality, personal factors, and student background. Readers are responsible for providing numerical ratings for academic, extracurricular, personal, and essay categories. What's interesting is they don't call out athletics and recruited athlete status as strongly as Harvard does. Maybe that's folded into extracurricular. During the years at issue in this litigation, underrepresented minority students were more likely to score highly on personal ratings than their white and Asian peers, but were more likely to be rated lower on academic program, academic performance, and extracurricular activities and essays. After assessing an applicant's materials along these lines, a reader formulates an opinion and then writes a comment defending his or her recommended decision. In making that decision, readers may offer students a plus based on their race, which may be significant in an individual case. The admissions decisions made by the first readers are in most cases provisionally final. Following the first read, applicants go into a process called school group review, where a committee composed of experienced staff members reviews every decision or review, receives a report on each student, which contains class rank, GPA, test scores, okay, very reasonable, the ratings assigned to them by their initial readers, okay, and their status as residents, legacies, or special recruits. Ah, ha, ha, there it is. Oh, my God. You know, you got to wonder, out of a class of students, how many were in the recruited athletes? It's probably a larger percentage than you might think, given, you know, some teams are like 40, 50 people, right? Anyway, the review committee either approves or rejects. Oh, by the way, I know we mentioned that we were going to go straight into the primary source material. I should disclose ahead of time my bias. I am in favor of affirmative action. I think it's the right thing given the history of this country and how certain groups have been deprived of opportunity and you know, have had generations of discrimination against them. So I'm very, very supportive of affirmative action. I will say that I think how it's implemented is very important, and understanding how it impacts all citizens is important to take into consideration. And full bias up front. If I have a dog in this fight, I believe that legacy status and athletic ability should be much lower weighting. It's striking how important it is, appears to be, based on the Supreme Court opinion. Now you might say, well, that's easy for you to say, Tom. You don't appear very athletic, and that is true. That is true. But at the end of the day, like, do you go to college to learn how to be a D1, you know, athlete, or do you want to go and become a student and learn and maybe participate in athletics? You know, certainly nothing against varsity sports and D1 sports, but wouldn't it be, why wouldn't it be something where you're admitted largely based on the academics, and then you happen to be, you know, a squash player or whatever? Daniel B says, the road to hell is paved with good intentions. Well, that can be true sometimes. So let's keep reading. So they look at the ratings by initial readers, resident status. That makes sense, especially if you're UNC. Legacies, I see why they do that. I see that they probably feel like, hey, people are more loyal if they're like multi-generational. You know, if you really want to take the pure meritocracy route, then legacy status should be looked at. And then athletic recruits. I mean, I get it. Like, if you have a winning football team, you know, you're probably going to get more donations. Alumni are going to feel more fired up. It's more fun as a student to go to a winning, you know, a team where you win all the time. You know, how important is that relative to academic readiness is a different question. The review committee either approves or rejects each admission recommendation made by the first reader, after which the admissions decisions are final. Okay. Okay, what happened here? Looks like a lot. Petitioner, Students for Fair Admissions, SFFA, is a nonprofit. Purpose is to defend human and civil rights, including rights of individuals to equal protection. SFFA filed separate lawsuits against Harvard and UNC, arguing that their race-based admissions process violated, respectively, Title VI of the Civil Rights Act of 1964, the Equal Protection Clause of the 14th Amendment, The district courts in both cases held bench trials to evaluate the claims. Trial in the Harvard case lasted 15 days, included testimony from 30 witnesses, after which the court concluded that Harvard's program comported with our precedents on the use of race in college admissions. Okay, so the lower court did look at this, and it looks like they sided with Harvard, saying this is consistent with precedent. Similarly, in UNC, district court concluded after an 8-day trial that the UNC admissions program was permissible under the Equal Protection Clause. Okay. So then the Supreme Court says, well, we granted certiorari in the Harvard case and certiorari before judgment in the UNC case. Maybe that just means they said, we'll take a look. Before turning to the merits, we must assure ourselves of our jurisdiction. Okay. Well, let's assume they have jurisdiction. And the people have standing. Okay, then they go into standing. Blah, blah, blah. I want to get into, like, what did they actually decide and why? I think we're still in the standing case. Okay. Opinion of the court. So we basically spent 20 minutes giving the introduction, establishing that the lower courts had sided with Harvard and UNC. And then there was a bunch of stuff that we skipped over, which said that they had standing. Now, let's get hopefully to the good part. In the wake of the Civil War, Congress proposed and ratified the 14th Amendment, providing that no state shall deny any person the equal protection of the laws. To its proponents, the Equal Protection Clause represented a foundational principle, the absolute equality of all citizens of the United States politically and civilly before their own laws. The Constitution, they were determined, should not permit any distinctions of law based on race or color, because any law which operates upon one man should operate equally upon all. As soon to be President James Garfield observed, the 14th Amendment would hold over every American citizen without regard to color, the protecting shield of law. And in doing so, Senator Howard, the amendment would give the humblest, the poorest, the most despised of the race the same rights and same protection before law as it gives to the most powerful, the most wealthy, or the most haughty. For without this principle of equal justice, there is no Republican government and none that is really worth maintaining. At first, the court embraced the transcendent aims of the Equal Protection Clause. What is this? We said in 1880, but declaring that the law in the state should be the same for black as for white, that all persons, whether colored or white, shall stand equal. Okay? I think so far so good. 14th Amendment applied to all persons. Despite our early recognition of the broad sweep of the Equal Protection Clause, quickly failed to live up to the core commitments. For almost a century after the Civil War, state-mandated segregation was in many parts of the nation a regrettable norm. This court played its own role, allowing Plessy versus Ferguson, separate but equal regime. After Plessy, American courts labored with the doctrine for over half a century, Brown versus Board of Education. So they go into a long history of all of the injustices despite having the 14th Amendment. Let's see, that goes in 1950. Culmination finally came in Brown versus Board. Overturned Plessy for good and set firmly on the path to invalidating all de jure racial discrimination by states and federal government. Okay, that's good. The conclusion reached by the Brown Court was thus clear. The right to a public education must be made available to all on equal terms. So as you can see in this opinion, what I think we're setting up is the argument that the 14th Amendment basically says the law should be applied equally and should be, colorblind, let's say. And I think they're going to make the argument that that's not what's happening in college admissions. College admissions is trying to correct a wrong and maybe, try and help groups that have been, um, you know, disproportionately harmed in the past to kind of catch up and level the playing field in terms of access to future opportunities. And it sounds like what they're saying is no. The laws, the 14th Amendment says you just apply the law equally. It says nothing about kind of truing up any false previous, like, um, you know, poor outcomes or sins of the country. The conclusion reached by Brown was thus clear, okay, equal on all terms. The court reiterated a rule for 1 year later, holding that full compliance required schools to admit students on racially non-discriminatory basis. So too in other areas of life, we routinely affirmed lower court decisions that invalidated all manner of race-based state action, affirmed a decision that required segregation in busing. As the lower court explained, the Equal Protection Clause requires equality of treatment before the law for all persons without regard for race or color. So I think they're basically going to say, look, we've been doing this. It's good. It's all about equality. It's all about being treated the same, regardless, irrespective of your race. And then they basically give like a million examples of previous cases. Okay, so here's their kind of key, I think, argument. Eliminating racial discrimination means eliminating all of it. And the Equal Protection Clause applies without regard to any differences of race, of color, or nationality. It is universal in its application. For the guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to a person of another color. If both are not accorded the same protection, then it is not equal. Any exception to the Constitution's demand for equal protection must survive a daunting two-step examination, as in our cases as strict scrutiny. Under the standard, we ask whether the racial classification is used to further compelling government interests. So they're saying there are times when you can consider race if it is further compelling government interests. Second, whether the use of race is narrowly tailored and necessary to achieve that interest. So they are opening the door saying like, hey, you can consider race, but it has to be for compelling government interests and narrowly tailored. Now, one could argue that it is absolutely in the governmental interest to address generations of discrimination and mistreatment of certain racial groups. Like, I could say that is in our government's interest, just in the interest of justice and fairness. Now, and then narrowly tailored, you could say, well, Harvard, UNC, they're not saying, that those are two schools. These highly selective schools, there's not that many of them. But let's keep going. Outside the circumstances, our precedents have identified two compelling interests. One is remediating instances of past discrimination. Okay, yeah, great. The second is avoiding imminent and risk to human safety in prisons, such as a race riot. Oh my. Okay. Our acceptance of race-based state action has been rare for a reason. Distinctions between citizens solely because of their ancestry are by their very nature odious to a free people. Okay. These cases involve whether a university may make admissions decisions that turn on an applicant's race. Our court first considered the issue of Regents of UC versus Bakke, which involved set-aside admissions program used by UC Davis Medical School. Each year, the school held 16 of 100 seats for members of certain minority groups who were reviewed on special admissions tracks separate from the main admissions pool. The plaintiff, Alan Bakke, was denied admissions 2 years in a row despite the admission of minority applicants with lower GPAs and MCAT scores. Bakke subsequently sued the school, arguing that its set-aside program violated equal protection. In a deeply splintered decision that produced 6 different opinions, none of which commanded a majority, we ultimately ruled in part in favor of the school and in part in favor of Bakke. Justice Powell announced the court's judgment, and his opinion, though written for himself alone, would eventually come to serve as a touchstone for constitutional analysis of race-conscious admissions. Powell began by finding 3 of the school's 4 justifications for his policy not sufficiently compelling. The first justification of reducing historic deficit of disfavored minorities in medical schools, he wrote, was akin to preferring members of any one group for no reason other than race and origin. Yet that was discrimination for its own sake, which the Constitution forbids. Yeah, that's interesting. So they're basically saying, look, even if there was previous disfavored treatment, any solution that involves preferring members of one group violates the Constitution. Now, if you had a constitutional amendment that said the government has a right to make amends for previous disfavorable treatment, then you and that would justify at times some, very narrowly tailored consciousness of race. Then maybe that wouldn't be a problem, but obviously getting a constitutional amendment is hard or near impossible these days. But that's what Roberts is citing now. He's saying, hey, Powell said that, you can't discriminate. You cannot prefer members of any one group for any reason, even if you had a good reason. Justice Powell next observed that the goal of remedying the effects of societal discrimination was also insufficient because it was an amorphous concept of injury that may be ageless in its reach into the past. Okay, I see that argument, but I kind of feel like it's pretty clear it's not that amorphous when you enslave a whole group of people and deprive them of basic rights of property and education. Like, that's not amorphous. It wasn't that long ago. But at any rate, finally, Powell found that there was virtually no evidence in the record indicating that the special admissions program would increase the number of doctors working in underserved areas. Oh, that's interesting. So apparently, maybe if you bring in underrepresented folks, but what you could do is then you could have a program where you say, look, we're going to have a special admissions program for underrepresented applicants, and part of the program is that you have to then go work in an underserved area for the next 5 years after you graduate, or do your residency in an underserved area, or I know I'm solutioning, but can't help it. Justice Powell then turned to the school's last interest, asserted to be compelling, obtaining the educational benefits that flow from a diverse student body. That interest, in his view, was a constitutionally permissible goal. Okay, so the Supreme Court is saying, at least Powell was saying, look, if you're making the argument that a more diverse class creates a more beneficial experience for everybody in that class, like, we're okay with that. And that might be why you see Biden now kind of pushing that argument pretty hard. But a university's freedom was not unlimited. Racial and ethnic distinctions for any sort are inherently suspect. and antipathy towards them was deeply rooted in our constitutional and demographic history. A university could not employ a quota system for reserving a specified number of seats in each class for individuals from preferred ethnic groups, nor could it impose a multi-track program with a prescribed number of seats set aside for each identifiable group category of applicants, and neither still could it use race to foreclose an individual from all consideration. The role of race had to be cabined, or is that cabined? I've not seen that word used that way. Assume it's cabined. It could operate only as a plus in a file, and even then, race was to be weighed in a manner flexible enough to consider all pertinent elements of diversity in light of the particular qualifications. Powell derived this approach from what he called illuminating example of the admissions system used by Harvard. Under that system, described by Harvard, the race of an applicant may tip the balance in his favor, just as a geographic origin or life experience may tip the balance in other candidates' cases. Harvard continued, a farm boy from Idaho can bring something to Harvard College that a Bostonian cannot. Similarly, a black student can usually bring something that a white person cannot offer. The result, Harvard proclaimed, was that race has been and should be a factor in some admissions decisions. No other member of the court joined Powell's opinion. 4 justices instead would have held that government may use race for the purpose of remedying. 4 of them would have held that the government may use race for the purpose of remedying the effects of past discrimination. That makes sense. 4 other justices would have struck down the Davis program as a violation of Title VI. In their view, it seemed clear that proponents of 6 assumed that the Constitution required a colorblind standard on the part of the government. The Davis program, therefore, contravened a core principle. Okay. Wow, this, by the way, Supreme Court opinions, my goodness, are long. Let's take a little break, because what's interesting is there's so much time spent on the kind of historic decisions, which kind of makes sense since that it's a system of precedents. It's kind of like law school 101 probably. But let's go to the chat briefly, say hi to some people. Kevin is saying there's a reason why biracial applicants are advised not to check Asian when it comes to race. Lots of white students at highly selective students have an Asian mother but a Western surname. Yeah, I could see that. I could see if you were Bob Jones, you'd probably have you might have a better chance than if you were Bob Chang on your application. Good to see you, Jeremy. Welcome to the live show, and thank you for being a member. And also, Kevin, thank you for being a member. And if you guys are not members and enjoying the stream, click the join link. It helps me continue this channel, keep it going. Doesn't cover all the costs. It's like $100 a month total right now, but it helps with some of the streaming costs and the podcast hosting fees. By the way, if you listen to audio podcasts, subscribe wherever you listen to audio podcasts. Okay. Kailani, when Polynesians became a separate race category in the 90s, for decades, it was only an API box. Our numbers more than tripled right away at highly selective universities. Yes. If you have to go, that API box, that generally not considered to your advantage. I remember when I was applying to college, some of my classmates were like, "Oh, Tom, you're so lucky as an Asian, you'll get special treatment when you apply to college." I was like, I don't know if that special treatment will increase likelihood of admission. Daniel B says, household zip code would accomplish the spirit of affirmative action better. Yeah, I could see that. Or socioeconomic status. I kind of feel like if there were, which is more beneficial to society, giving a tip, a little edge to a super poor white person from West Virginia, parents never went to college, but has great grades and great essays, interviews well, great test scores, or maybe a second generation African American student. Uh, Parents went to elite schools, lives in very fancy area, has gone to the best high schools. Like, I don't know. I kind of feel like that poor West Virginian kid, or a poor black student who is first generation college, has overcome a lot, even more adversity. So I kind of feel like economic resources should be a major factor. Like, if folks have already done well and are on an upward trajectory, then they should just be looked at maybe like anybody else. On the other hand, if you are in a very underserved area and you've had very little access to resources, then I totally think you should get extra consideration because it was so much harder for you to get the grades that you got. If you're a straight A student with a difficult family situation, without a history of going to college, with a school that's high school that's under resourced, like, and you get like great SAT scores, like, my God, you should be not auto accepted, but like highly, given a lot of preference, in my opinion. And I think that's consistent with how schools are designed to operate, to reward, be a meritocracy and acknowledge the difficulty factor of achieving similar looking outcomes. Anyway, let's keep going on the comments. Kalini says, makes zero sense to rectify past wrongs. Schools can discriminate. Oh, it makes it that in order to rectify past wrongs against African Americans, schools can discriminate against Asians. Yeah, that's true. I think I agree. I think if there's anyone that should disproportionately, let's call it, contribute to the budget of resources for rectifying old wrongs, that budget should come from the groups that have benefited the most from those wrongs. And I would argue that there's tons of Asian Americans who had nothing to do with like the 1800s, like slave ownership or concentration of resources. I mean, as many of you know, Asian Americans weren't even allowed to vote or own property for a long time, and Chinese were, I think, the only group that were written into law where you could not immigrate to the country based on race if you were Chinese. And Chinese women were not able to immigrate because they were worried that the Chinese would reproduce. So, yeah, I kind of agree with you that I would not have said, oh, you know what? In order to remedy the scourge of our country's original sin, which is slavery, we should take away opportunity from Asian Americans. That to me is a little odd, but let's keep going. Leslie said, this is an excellent topic. We'd love to interview some of my classmates from Stuttgart High School class of 72. Well, that might be interesting, Leslie. Stuttgart, Arkansas. I thought it might be Stuttgart, Germany. Yeah, that would be interesting, Leslie. Hit me up. Just message me if you want to, if any of your classmates would be up for that. Okay. And then lastly, Kalini is saying the fact that the concept and term overrepresented minority was widely used and accepted in college admissions is a sad reflection of their myopic views on race. Yeah, I think that's also fair. There's a lot of Asian Americans who are extremely poor and have grown up in extremely distressed circumstances. I was very lucky. I grew up pretty much middle class, upper middle class. My parents were college graduates and had graduate degrees, so like I had a lot of advantages, but not all Asians fit that profile. And to kind of make it harder, if this is what happened, for some Asians to apply, like that's unfortunate. Okay, let's keep going, and I'm going to have to wrap in about 10, 12 minutes because I've got another commitment coming up. But in the years that followed, okay, are we ever going to get to the actual decision? So there's a lot of background. Let's see if we can skip to the part where we are not talking about Justice Powell. I feel like this whole live stream was more about the previous decisions. Oh, come on, Roberts, just tell us what's the TLDR. Okay, maybe we're getting there. Okay, 20 years later, no end is in sight. Harvard's view about race-based admissions will end doesn't have a date on it, but we have permitted race-based admissions only within the confines of narrow restrictions. University programs must comply with strict scrutiny. Okay, here we go. I think now we're getting into the juice. First, the interests that they view as compelling cannot be subjected to meaningful judicial review. Harvard identifies the following benefits: training future leaders, preparing graduates to adapt to a pluralistic society, educating students through diversity, producing new knowledge. UNC points to promoting exchange of ideas, broadening understanding, fostering innovation, preparing engaged citizens, enhancing appreciation, respect, empathy, cross-racial understanding. Although these are commendable goals, they are not sufficiently coherent for purposes of strict scrutiny. At the outset, it is unclear how courts are supposed to measure any of these goals. How is a court to know whether leaders have been adequately trained, whether the exchange of ideas is robust? Even if these goals could be measured, how is a court to know when they have been reached and when the perilous remedy of racial preferences may cease? So they're basically saying like all these arguments in favor of it sound fine, but how will we, if this is like a temporary measure, like how will we know if this is working, and how will we know when it should be sunsetted? Finally, the question in this context is not of no diversity or of some, it is a question of degree. How many fewer leaders Harvard would create without racial preferences, or how much poorer the education at Harvard be, are inquiries no court can resolve. Comparing respondents' asserted goals to interests we have recognized as compelling further illustrates their elusive nature. In the context of racial violence in prison, for example, courts can ask whether temporary racial segregation will prevent harm. When it comes to workplace discrimination, courts can ask whether a race-based benefit makes members of the discriminated class whole for the injuries they suffered. And in school segregation cases, courts can determine whether any race-based remedial action produces a distribution of students comparable to what it would have been in the absence of such violations. Nothing like that is possible when it comes to evaluating the interests of respondents to assert here. Unlike discerning whether a prisoner will be injured, the question of whether a particular mix of minority students produces engaged and productive citizens sufficiently enhances appreciation, respect, and empathy, or effectively trains future leaders is standardless. The interests that respondents seek, though plainly worthy, are inescapably imponderable. Oh, beautiful writing. Okay, so they're basically saying, look, we like what you're trying to do. It's just impossible to measure it. Second, respondents' admissions programs fail to articulate a meaningful connection between the means they employ and the goals they pursue. To achieve the benefits of diversity, UNC works to avoid underrepresentation of minority groups, while Harvard guards against inadvertent drop-offs. To accomplish these goals, the universities measure the racial composition of their classes in the following categories: Asian, Hawaiian Pacific Islanders, Hispanic, White, African American, Native American. It is far from evident how assigning students to these categories furthers the educational benefits that they claim to pursue. For starters, The categories are themselves imprecise. Some of them are plainly overbroad by grouping together all Asian students. Respondents are apparently uninterested in whether South Asian or East Asian students are adequately represented, so long as there's enough for one to compensate. Well, yeah, that is true. You could have that is true. Like if you had a class where it was all Indian Americans, like South Asian Indian Americans, and there were no Chinese Americans, like that would be less diverse. And similarly, if it were all Korean Americans and no Japanese Americans, that also would be less diverse. So I kind of see where they're coming from. Meanwhile, in other categories such as Hispanic, they are arbitrary or undefined. Who is Hispanic? What does it mean to be Hispanic or Latino today? And still, other categories are under-inclusive. When asked at oral argument, how are applicants from Middle Eastern countries classified? Jordan, Iraq, Egypt. UNC counsel responded, I do not know the answer to that question. Oh, God. Yeah. So, like, I think they're saying if you're for diversity, then try and think about all of the different groups. I suppose the counter argument would be, well, it is diversity, but it's also kind of remedying historically discriminated against groups, and the most discriminated against groups are sufficiently captured in the current taxonomy. Maybe that's the argument, the counter argument. Indeed, the use of these opaque racial categories undermines instead of promotes goals. By focusing on underrepresentation, respondents would apparently prefer a class with 15% of students from Mexico over a class of 10% students from several Latin American countries, simply because the former contains more Hispanic students than the latter. That's an interesting argument. Yeah, so I think they're saying, look, if you want diversity, then make it diverse. You don't want all your students from California and New York. You do want the people from Wyoming and Kentucky and stuff. And similarly, Hispanic covers a pretty broad area, just the way Asian does. Yet it is hard to understand how a plan that could allow these results can be viewed without being concerned with achieving enrollment that is broadly diverse. And given this mismatch the respondents employ and the goals they seek, it is especially hard to understand how courts are supposed to scrutinize these programs. The university's main response to these criticisms is, trust us. None of the questions recited above need answering, they say, because the university are owed deference when using race. It is true that our cases have recognized a tradition of giving a degree of deference to university academic decisions, but we have been unmistakably clear that any deference must exist within constitutionally prescribed limits, and that deference does not imply abandonment or abdication of judicial review. Okay? The race-based admission system that respondents employ also fail to comply with the twin commands of the Equal Protection Clause and may not operate as a stereotype. First, our cases have stressed that an individual's race may never be used against him. Here, however, First Circuit found that Harvard's consideration of race has led to a 11.1% decrease in the number of Asian Americans admitted to Harvard. And the district court observed that Harvard's policy of considering race overall results in fewer Asian American and white students being admitted. Well, yep. That kind of makes sense. If you're going to admit more of one group, there's going to be another group that is going to have to give up some spots. And apparently, Asian Americans are a big one. Respondents nonetheless contend that an individual's race is never a negative factor. Harvard, for example, draws an analogy between race and other factors. While admissions officers may give a preference to applicants likely to excel in the orchestra, that does not mean that it is a negative not to excel at a musical instrument. But on Harvard's logic, while it gives preference to applicants with high grades and test scores, that does not mean it is a negative to be a student with lower grades and lower test scores. This understanding of the admissions process is hard to take seriously. College admissions are zero-sum. A benefit provided to some, but not to others, necessarily advantages the former group at the expense of the latter. Respondents also suggest that race is not a negative factor because it does not impact many admissions decisions. Yet at the same time, respondents also maintain that demographics of their admitted class would meaningfully change if race-based admissions were abandoned. Yeah. So they're saying, hey, look, if the schools are saying, hey, this doesn't really, affect that many decisions, then you can't say, hey, if you don't let me do this, the whole class is going to look completely different. Those two things can't be true at the same time. And they acknowledge that race is determinative for at least some, if not many, of the students they admit. How else but negative can race be described if, in its absence, members of some racial groups would be admitted in greater numbers than they otherwise would have been? The equal protection is not achieved through indiscriminate imposition of inequalities. Respondents' admissions programs are infirm for a second reason. We have long held that universities may not operate their admissions programs on the belief that minority students always express some characteristic of minority viewpoint on an issue. That requirement is found throughout our Equal Protection Clause. This court has rejected the assumption that members of the same racial group, regardless of their age in which they live, think alike. This makes sense. Like, this is one of those situations where you can't just ask, like, one Asian person or one Hispanic person, like, speak on behalf of your whole race. So what they're saying here is, by accepting race-based admissions in which some students obtain preferences on the basis of race alone, respondents' programs tolerate the very thing Grudder forswore, which is stereotyping. The point of respondents' admissions programs is that there is an inherent benefit in race for racist sake. Respondents admit as much. Harvard admissions process rests on the pernicious stereotype that a black student can usually bring something that a white person cannot offer. It argues that race in itself says something about who you are. Yeah, that's an interesting one. I mean, I don't think I'm as convinced by the Supreme Court on this one. Like, I do think if you are of a race, yes, by definition, you are treated differently. And you have experience that others don't. And if there aren't a lot of people of that race in the class, then the class does miss out. So I don't find this argument as convincing as the other one about measurability and the negative impact on other races. We have time and time again formally rejected the notion that government actors may intentionally allocate preference. One of the principal reasons race is treated as a forbidden classification is that it demeans the dignity and worth of a person judged by ancestry instead of their merit and qualities. But when a university admits students based on the basis of race, it engages in the offensive and demeaning assumption that students of a particular race think alike. Okay. The university further stereotypes that treat individuals as a product of their race. If all this were not enough, respondents' admissions programs lack a logical endpoint. Respondents and government first suggest that respondents' race-based admissions will end when and in their absence there is meaningful representation and meaningful diversity. The metric of meaningful representation, the respondents assert, does not involve any strict numerical benchmark or precise number. Numbers all the same. At Harvard, each full committee meeting begins with a discussion of how the breakdown of the class compares to the prior year. And if at some point in the process it appears that a group is notably underrepresented or suffered a dramatic drop, the admissions committee may decide to give additional attention to applicants from students within that group. Harvard uses race to track how each class is shaping up relative to previous years with an eye towards achieving a level of racial diversity. The results of the Harvard admissions process reflect this numerical commitment. For the class of 2009 to 18, black students represented a tight band of 10 to 11.7% of the admitted pool. The same theme held true for other minority groups. Oh, yeah. Yeah. You can see clearly some consistency here. I did not mention this, but I should disclose another bias. I am a graduate of Harvard University myself. I attended graduate school there. I don't know if that makes me more of a defender of Harvard or a critic. Hopefully you'll find that my observations I try to be even-handed, but I would put that out there in case some of you feel like it's being like hidden from you. Yes, I did go to Harvard for my MBA. Okay, now UNC's admissions program is similar. University frames the challenge as admission and enrollment of underrepresented minorities. University has not yet fully achieved its diversity-related goals. The problem with these approaches is well established. Okay, so I think they're saying that same thing at UNC. Same argument about how you can never end it. 5 more years. That 25 years from now, the use will no longer be necessary. The 25-year mark reflected the court's view that race-based preferences would end by 2028. That expectation was oversold. Neither Harvard nor UNC believes that race-based admissions will be unnecessary in 5 years, and both universities expect to continue. Indeed, the high school applicants at Harvard and UNC will evaluate this fall using race-based admissions are expected to graduate in 2028. Finally, respondents argued that their programs need not have an endpoint to determine whether they remain necessary. Harvard concedes that its race-based admissions program has no endpoint. Okay. All right. So we are at time. Let's try and summarize. My God. Let's go to the comments. Hey, Soldier One. Thanks for being a member and a huge member. Attending Harvard shouldn't be considered a black mark. You studied at MIT. Good stuff. Good stuff. Well, if you ever need someone to do some hard science, I definitely would hire someone from MIT for sure. That said with love, Soldier One. Okay, so let me do 2 things. I'm going to thank our members, and then I'm going to give you my takeaways and summaries, and then I'm going to talk about whether or not I should do another live stream about the dissenting opinion from Justice Sotomayor, because I think it would be kind of interesting to read her dissenting views and see how she kind of comes back at Roberts. But before we do that, and before I summarize, let me give a quick thank you, and we'll turn on some Nerds for Humanity closing music. All right. So why did I just spend an hour reading a Supreme Court opinion? Well, part of it is because I know people care about this content. It's not a huge number, but there are people that value this stuff. And the people that are most prominent in supporting this channel are our channel members. And if you're listening to this and you like what you're hearing and you want to become a channel member, just click the join link on YouTube. The same way that members have already done, including, let's share the screen, Soldier One, our biggest freaking member, senior vice president, supporting this channel for 39 months. Thank you, Soldier One. Vice president level, we have Kristen Slevin and Bike, huge supporters as well. Kristen Slevin's at the 42-month mark of support for Nerds for Humanity. Hardcore nerds: Gene, David, DK, Jackalego, Curse, Mr. History, Mona, Vaughn, Yang, Robert, Dean, Galessa, Jay Perrin, AH, Dana, Jason, Daniel, and Mickey. and then verified. You know, you guys can become a verified nerd for $1.99 a month, and this is an unprofitable channel. We do not make more money from our members and ads than we do paying for streaming and podcast hosting. So every dollar counts. Lisa, Albert, Brandon, Sophia, Doris, Emerald, Ben, James, Ira, Elizabeth, Shoni, Dr. William, Karen, Zemery, Mai, Brittany, Lori, Wana, Kevin, Nija, Jeremy, David, Nicholas, Mike, Aurora, Zig, and Carter, Roberto, and Jackson. And our youngest members overall, who's our youngest? Who's our youngest nerds? They would be Jackson, Roberto, and N. Carter. We haven't had a new member in the last 4 months. Jackson's the youngest. And then the oldest are Lisa, Jean, Kristen, Albert, and Brandon, 42 months old. So thank you, nerds. All right, so now let's summarize here. Soldier One, I love the MIT Harvard stuff. If you need someone to, there you go. It's a perfect match. So, and yes, Soldier One, we hope that we'll become profitable maybe as the next election. You know, I'd be fine if we just cover the costs. And frankly, like, it's not that expensive. So I don't mind paying a little bit to keep this going. But I think having the members show that you guys value this. Sometimes I'm like, oh, should I do another stream this week? And maybe I'm kind of tired, had a long week at work. And knowing that I've got members that value this stuff means that, like, I do get on and we do these streams. So quick summary, 3 things. Number 1, I think the country still needs affirmative action. I think it should be part of highly selective and all college admissions. I think the way they do it, where it disproportionately harms Asian American applicants, should be changed. And the biggest donors to affirmative action should be the biggest benefits of those previous wrongdoings, which I don't think are Asian Americans. And third, we have to look at how highly selective colleges look at recruited athletes, rated athletes, and legacy students. Because if you're not able to give preferential treatment based on race, including applicants from historically underserved races, but you are still going to give preference to, like, the squash team, the hockey team, the football team, the lacrosse team, the soccer team, and the sons and daughters of previous graduates, like, that seems totally unfair. So that's my takeaway. Let me know in the comments what you think. And also, if this stream and this replay gets, let's say, how many likes do we usually get? I'll say if it gets 25 likes, which we should be able to get, hopefully, then I'll do another one where I go over Justice Sotomayor's dissent. With that, I'll say goodbye, nerds. And Jackson, I'm glad you appreciate it. I sprinkled a little bit of opinion in there, but hopefully it was centered around the primary documents, the primary data, the primary evidence, and we didn't do too much of the bumper sticker kind of debate style that is so common right now. So with that, I'm going to say goodbye, nerds, and thanks again, members. And if you're not able to join as a member, you're like, hey, I don't want to pay money for freaking Nerd Channel, what you could do is give this thing a like and share and comment. That's free. All right, keep it real. Goodbye, nerds.